second presentation today is about return to office trends, best practices, developments. We are going to be touching a lot on the return to office trend, which a lot of employers, especially in the Bay Area, are implementing, especially right as we speak in this month of 2025. But we'll also touch on some of the legal implications and developing trends, litigation risks, et cetera, associated with hybrid workforces and people still working from home quite a bit. So that's what we'll be covering today. You met me earlier, but let Ben introduce himself.
Hi, I'm Ben Buchwalter. I'm special counsel here in Farella's mighty employment, counseling, and litigation team. Really glad to be with you today. So as we've done before already today, let's kick this off with a little poll. If you're here in the room, please raise your hand, or if you're online, you can give us a thumbs up, or maybe a thumbs down if you don't like the answer. So first of all, how many of you work in a place that is requiring you to come into the office 5 days a week? Okay, a few hands here. And how about how many of you have a hybrid model where you're required to come in a certain number of days a week, but not every day? Okay, a few more hands, admittedly some from our office. And how many of you have no requirements about how many days you need to come in, or you're remote entirely? Just a few hands here. Okay. Well, we're hoping that today, no matter what your answer was, we'll be answering some questions that apply to all types of employers, whether you're coming in all the time, just a few days a week, or not at all.
So in terms of the specific agenda, we'll first touch on some challenges that we're seeing around return to office policies and mandates. We'll then turn to litigation risks. So what are we seeing in terms of different litigation areas that are cropping up all over the place, wage and hour, expense reimbursement, reasonable accommodation and disabilities, disability-based harassment, and then other kinds of harassment and discrimination claims, breach of contract, and then collective action. We'll touch on that as well. We'll also mention some local ordinances that may be of interest to folks who have employees here in San Francisco and in Berkeley. And then we'll close with some best practices that we recommend in terms of return to office mandates and expectations.
So let's start with discussing why it's important to get this so right. Most employers that I talk to, they're considering this balance between making sure work gets done efficiently and also caring for the well-being of their employees. That's a really difficult balance to make when you're going from a situation where people are working entirely from home to all of a sudden changing their routine to come into the office. So as you can see from the headlines here, we have some examples of maybe employees feeling like that balance wasn't hit correctly. You see some examples here of people feeling very uncomfortable coming back into the office, and maybe even pushing back against that. And also, of course, one of the common challenges that we see when employers move from a remote environment to asking people to come into the office is the unfortunate reality of losing some key talent. So we're going to dig in a little bit more to some of these challenges that we've been seeing from return to the office policies. So again, like I just mentioned, I think the key one is the potential to lose key talent from resignations. During the pandemic, one thing that was so great was, not a lot was great about the pandemic, but one thing that sometimes worked to employers' benefit was that all of a sudden there was an emphasis on recruiting from anywhere in the country. So you would get the best talent no matter where people were located. A lot of employers touted that, and sometimes while you've been requiring the people to come back into the office, it's a bit of a challenge because you're saying, okay, maybe I'm based in San Francisco and I have this great engineer out in the Twin Cities. All of a sudden, I'm asking you to relocate to where we're based. And that person might just say, I'm not going to. I'm going to stay in my home and find another job that allows me to work remotely. Another speaking of, there have been reports that have looked into how much talent has been lost as people have been moving to office atmosphere. One study showed that 8 in 10 companies lost talent as a result of that decision. And even if people aren't straight up resigning, you've seen some quiet quitting. And as you know, that means, maybe they're not resigning, but they're pulling back. They're pulling back on their engagement, maybe on a permanent basis, or maybe while they're seeing what else is out there, seeing if there are other remote opportunities out there that might fit their needs a little better. Another key consideration is if you're going to be requiring people to come into the office a few days a week, how are you going to be tracking that? Are you going to be tracking, employees' badges when they come in? Some employees don't like that idea that you'll be monitoring when they're coming in. And then if you are, consider what does it mean to count them for a day? If they come in and scan their badge and show up for 15 minutes and then go home and finish the day there, does that count to meet the quota that you're expecting? This is what, has been called coffee badging. I've seen this in the news a little bit more recently, where people will badge in, come have lunch or a coffee with their colleague, and then, hit the road and go home and finish the day there. And the idea being that they've met their obligation. And then finally, lawsuits. Chandra and I will be spending the next few slides talking about some of the challenging lawsuits that we've seen stemming out of return to office policies.
So the first topic we would touch on in terms of return to office kind of follows Kevin's commentary on wage and hour issues. A lot of these things are in parallel with wage and hour issues that have been around forever, right? But when it comes to bringing people back into the office, especially folks who started during the pandemic, and especially again for hourly workers, folks who are now going to be commuting, they're going to have a slight change in schedule, right? Or maybe a significant change in schedule. And so for those folks, once again, especially the hourly workers who are going to be transitioning to a more significant time in the office, you're going to have to think about how is that going to impact their schedule in terms of their expected hours worked, when they're going to be logging in, et cetera. And then there's special complications if hourly workers are going to be hybrid, right? Because then they're really applying themselves to 2 different timekeeping systems, and they have different potential schedules in different days. So you want to obviously make sure that the hourly employees are managing those 2 different timekeeping systems really correctly. As Kevin mentioned, you can get into a lot of trouble if you're not paying people for exactly how much time they're working. Another issue here is people maybe this has been an issue that's crept up during the pandemic for remote work, but hourly workers who are continuing to spend a lot of time working after hours, got to make sure all that time is paid. And if you're seeing someone emailing late at night, make sure that non-exempt employee is going to get paid for that. Another thing to look out for are potential role changes that can be associated with people transitioning from a fully remote work environment back to full-time in the office. You could think of a scenario where somebody, for example, was a management level employee who was pre-pandemic spending a ton of time with his or her team, managing people, engaging in those types of day-to-day in-person activities that are associated with managing a team. And then during the pandemic, that person went remote and suddenly their job duties shifted to, I'm going to be spending more of my time on administrative duties or just other non-managerial work. And then you're going to bring that person back to the office after however many years they've been remote. So you can imagine some shifts in job duties that you're going to want to look at with transitions from hybrid, in-person, remote, et cetera. So that of course bears on the exemption status and what job duties people are doing to be classified as an exempt employee. So another thing that again, Kevin touched on, but just as a reminder, for any sort of mandatory protocols that as a business you're requiring your employees to follow, this is maybe becoming a little bit more outdated, but people standing in lines to get their temperatures checked or fill out COVID related information forms, you have to pay for that time if they're not exempt. I just noted an Arizona case where Walmart paid $2.5 million in settlement recently for this type of unpaid time waiting to comply with COVID-related protocols. I'll note that the time period covered by that settlement was the high years of the pandemic, so from spring 2020 to February 2022. The California statute of limitations for wage and hour claims, as most of you probably know, is 4 years. So we are going to soon be aging out, hopefully, of a lot of these COVID era type wage and hour claims, but not quite, especially if these mandatory protocols lasted into the pandemic years. Other litigation risks that we're anticipating around return to office trends is, again, this kind of shift around expectations people have for expense reimbursements. There's a decision from the Central District of California last year, 2 years ago now, which looked at an employer's duty to reimburse employees' work from home expenses. Ms. Potts was an employee who had basically converted 30% of her home to a home office and apparently didn't tell Sirius, her employer, about this until she ends up resigning from the company and bringing a lawsuit and saying, hey, you didn't reimburse me for all of my expenses. And the employer's defense was, well, hey, we didn't know about it. How are we supposed to pay for expenses we didn't know you were incurring? And the court fortunately weighed in favor of the employer on this and said there's no duty to reimburse if you didn't know about it. But the decision uses this language that we as lawyers love and I think regular people hate, right? Which is you had a reason to know if there was an expense could apply. So it's you either knew or had a reason to believe there was an expense. So what does that mean? When I first read the decision, it seemed reasonable that the employer should assume somebody working from home would be incurring these expenses, but actually the court, again, favored the employer because the employer was able to point to policies that it had saying, if you are incurring expenses, here are the ways you're supposed to get reimbursed for that. And then they had, when people left, they had these expectations for people to submit any receipts within a certain period of time. So the court was able to look at those policies and say the employer here did not have a reason to know either because they had set up these systems. So obvious takeaway for you and your workforce is to make sure that you have a written policy around expense reimbursement, and a gold standard would be when people leave to have them fill out a form that says they don't have any other expenses they haven't told you about. This tie case, also from 2023, also involved pandemic era expenses. Here, the employee sought reimbursement for business expenses around a home office. The employer's defense was, well, we didn't order you to go work from home. It was the pandemic. The government ordered the shutdowns, and so we're not responsible for you having to set up a home office. It's COVID. It's the government. And the court here found against the employer on that issue and basically said, as you might expect, it's really whether there was a business expense incurred, not whether the employer was the proximate cause of ordering you to work from home, that sort of language. So just a kind of interesting argument there that the employer made. As Kevin already mentioned, for expenses that have a personal and a business use, cell phone use in particular, you should be reimbursing a reasonable percentage of that. You can do it stipend, or you can take a look and actually evaluate what percentage people are using for personal reasons. And then finally, just as a reminder with expense reimbursement, if as an employer you are providing your employees with office space to come back in and do their work from the office premises, you do not have to reimburse them for an office that they set up because they like to work from home once in a while. So it may be obvious, but there were some cases popping up during the pandemic that seemed to blur the line there a little bit. And then lastly, you don't have to reimburse people for their commute. So once you're bringing people back into the office, they may now be incurring more expenses than they were during the work from home years, and employers are not required to reimburse for that. Some employers may want to, though, for the reasons Ben said, people losing key talent with having to commute now. If you want to offer that as a nice perk to people that, hey, we're going to reimburse your commute costs. And so next we'll talk about reasonable accommodations.
Yeah, so we've also seen a lot of really interesting litigation around reasonable accommodations. When's the employer required to allow, for example, someone to work from home because of their disability, even if they have a return to office policy? I'd love to tell you that there's one way that it seems the courts are coming out on this. there's really not. It's a bit all over the place. So we're going to give a few examples. And the key takeaway here is really that it's going to depend on the specific facts at issue. It'll be a case-by-case determination by the court. So these three cases I'm going to talk about relate to situations where the employee asked to work from home on a full-time basis because of their disability. First up is this EEOC lawsuit that was filed against a Georgia-based payments company on behalf of an employee who had diabetes and hypertension. The EEOC said that, this was a customer service representative, but based on what they saw in the job description, a lot of their role required meeting with people, but not necessarily in person. So the EEOC said all of that could be done through technology, Zoom, Teams, whatever it is that the employer uses. And the EEOC said in a statement that their lawsuit, quote, serves to emphasize that the denial of telework is on the EEOC's radar. So it's an ominous statement, but I think we can all anticipate that maybe in a week or so, the EEOC's approach may change somewhat as we get into the new administration. But I think that attention that agencies are paying, remains important on the federal level, but particularly here in California. I think, that statement really aligns with what we're seeing in California for the most part. Which brings me to some of these California cases that we've seen recently come out of superior courts. Again, these kind of go on other sides. One is this Rodriguez case out of Orange County Superior Court, where the court ultimately denied summary adjudication on a failure to accommodate claim that involved an employee who had a leg and a foot injury who asked to work from home on a full-time basis. The employee also asked for some other accommodations, like a kind of fancy footstool to be at their workstation. Now, interestingly, the court found that based on the employee's job description, he actually did not meet a burden to show that he had to be in the office. And actually, that the court found that the employer's view that he had to be in the office actually was accurate. But the court ultimately found that that employer had denied the request to have the footstool that I talked about. And so on that ground, denied the summary adjudication motion. So this is sort of an example of where the employer sort of shot itself in the foot. Pun not intended. I genuinely not. But shot itself in the foot because, if they were going to require the employee to be in the office, the court was kind of on board with that. But there was this lower hanging fruit of the footstools that the employer did not provide. So one takeaway I would take from this case is that, if you're going to be asking people to be in the office, things like, these smaller seeming comforts that can help accommodate disabilities, I think are really important to get right. And that can make the difference between certain types of claims that you may get. Now, finally, there was another case out of Riverside County Superior Court that involved an animal service department customer services representative. Their job description identified roles like filing and said that the person may be required to handle animals in the office. The court still found that allowing the employee to work from home would not meaningfully affect their essential job duties. So basically, even though there were some parts of the job description that indicated they would have been required to be in person, for example, to handle the animals or to do the filing, the court wasn't convinced and said that given their disability, which is cancer related, they should be allowed to work from home on a full-time basis. So again, and also, there have been studies on this. Bloomberg had a study of the years between 2021 and 2023, and it found that there was a 10% drop in court judgments in favor of employers in accommodation failure cases. So what's the takeaway for how we address accommodation requests based on this kind of unpredictable environment? One is again, to focus on the essential functions of the employee's job. It's not going to be enough to say, we want people in the office because it's better for mentoring, it's better for morale. If you're going to make that argument, you need to be able to point to, what is it about this person's role that makes that so important? For example, if they're a salesperson, is it essential that they're having lunches with clients? If they're doing heavy amounts of office work, why is it that they need to be in the office to do that? Just really laying that out in the job description can be the best way to get ahead of those types of arguments. And then finally, as you all know, employers are not required to provide an accommodation if it would cause an undue burden on the employer. Now, sometimes past precedent here can get in the way of the employer's goals. It could be that if a company was implementing a remote first policy during the pandemic, they had some kind of language saying, we found that our employees are just as efficient from home as they are in the office. You may start seeing that language come back if you're going to be denying requests to work from home. That's not to say you can't do it, but it's just to be careful about, knowing what's out there, what you've said in the past, and maybe the reality is that 2 years later, you realize that completely wasn't the case, and everyone was watching TV from home when they were supposed to be working. But just to be conscious of that and prepared for it. And then finally, discrimination and harassment cases related to these requests to work from home or other accommodations in the office. Early on in the pandemic, we saw this related to different treatment between people who had been vaccinated and unvaccinated, or who didn't want to wear masks versus people who did want to wear masks. We're sort of moving away from that now because those issues just aren't as front and center for people anymore. But different issues are taking their place. And then finally, with respect to accommodations and these disability discrimination cases, a key factor is to think about, what is a covered disability? I think we're going to see different analyses of that going forward. What is long COVID and how does that manifest? We have some studies on it, but we're learning more every day. And then also taking COVID entirely out of the picture. Some people coming back to the office have realized that, maybe they have issues with depression or anxiety that makes it more difficult for them to be around people on a 40-hour-a-week basis, something that should be kept in mind. And also, though not a disability, one thing we saw recently was people requesting to work from home because it'll help with their childcare responsibilities. We're not aware of any law in California that says you need to take childcare into account specifically. Although in a minute, Chandra will be addressing a few local statutes that address flexible working arrangements and how you need to respond to that. And I should also note that, if you have a child who has a disability or some other reason, a medical reason you need to care for them, there could be an obligation to provide intermittent leave to an employee asking for leave on that basis. But just asking for a work from home accommodation based on the childcare needs probably wouldn't rise to the level of being an employer requirement, at least based on what we've seen so far. So I'm going to pass it back to Chandra to talk about a couple other litigation risks.
Yeah, just a couple of other ones here we won't spend too much time on, but one thing you can imagine people asserting, and we have seen an uptick in litigation along these lines, of people saying that they were basically promised either equitably or through a contract that they could work from home. So a lot of people who started during the pandemic may have felt like they were assured that they would continue to work from home regardless of changes in circumstance. So employees may be bringing breach of contract claims around that. Similarly around changes to their benefits or other reimbursements that they were reliant on during the pandemic years. In terms of collective action, just a note here that if you do have a unionized workforce, there has been an NLRB decision finding it an unlawful labor practice for an employer to fail to consult the union and try to bargain over a mandate to return back to the office. So something to keep in mind there. And then even for non-union workforces, the National Labor Relations Act does have this provision that it gives people a right to engage in collective action for their mutual aid and protection. So if you have employees griping about returning to office, but they're doing that in a collective way and they're kind of chatting about that at the workplace, if you try to discipline people for that activity, it could rise to the level of retaliation for engaging this type of collective action. So just another thing to be on the lookout for. And so back to the breach of contract thing, just probably worth double checking people's contracts if they have any. For folks who may have been fully remote during the pandemic, just make sure you double check those before you require them back in. So in terms of these local ordinances, San Francisco has the most interesting one and relevant for our program today. This is the San Francisco Family Friendly Workplace Ordinance, which was actually passed several years before the pandemic, but has taken on much more interest in recent years. So this ordinance gives certain employees the right to request flexible working arrangements for caregiving responsibilities. And that's regardless of whether that caregiving is related to a disability, as Ben was referencing earlier. So it only covers employers with 20 or more employees, but of course, a lot of employers meet that standard. And I've listed on the slide here the particular types of employees who can request these types of flexible work arrangements. The key thing here is that it basically requires an employer to engage in an interactive process with an employee who requests one of these flexible work arrangements for caregiving reasons. And the interactive process requirements are spelled out in quite some detail in the ordinance. So it looks a lot like the ADA, FEHA interactive process requirements, but it's more particular and it's assigned very specific time periods and whether it has to be in writing or not. So if you do get one of these requests from an employee who works geographically in San Francisco and meets these other requirements up here, just be on the lookout and know that this ordinance is probably going to apply. It definitely does not require you to allow people to work from home. It's again a similar analysis where an employer can show that it's an undue hardship to grant one of these types of accommodations for caregiving. And I should also note that employers can revoke arrangements that have been previously made, again, if they can point to an undue hardship and engage in another interactive process to basically negotiate another workable arrangement around this. The Berkeley Fair Workweek Ordinance doesn't actually touch on remote work or return to office at all, but it's a recent ordinance that came in last year, which basically recognizes that employees, in this case in the city of Berkeley, should have more predictability in their jobs and less of a burden around really exhausting schedules or being assigned to work without enough notice. And by the ordinance itself recognizes the importance of allowing workers to have more flexible predictability in their work-life balance. So just another kind of trend here in California, a lot of ordinances might be coming out along these lines. So just something to think about if you're getting requests from people that have to do with a more flexible work-life balance. All right, and then as far as our concluding talking points here, we just wanted to cover some best practices that we recommend for return to office expectations or mandates. The first one is just in terms of predictability. So, it's a good idea to evaluate, what is the type of return to office expectation that we think is right for our business. Consider starting gradually so people are able to rearrange their caregiving, et cetera, in order to adjust to coming back into the office. And certainly it's recommended that you have a written policy around this stuff. Written policies can lay out, what exactly the expectations are and also requirements and policies around that, tracking people as they're coming back to the office, like Ben mentioned. Consistency is going to be key. So for people who are coming back into the office, you want to make sure that you're treating them all the same, especially around this kind of tracking and holding people to the in-office expectations. You want to ensure equal enforcement to avoid claims of discrimination. That's not to say that every single person in every single division of your workforce needs to be treated exactly the same. You can have different policies or expectations for different teams. The engineers might have less of a reason to come back to work every single day. Maybe the salespeople should be in the office 5 days a week, and it's certainly fine and maybe helpful to have divisions across business lines or teams. But you should have that laid out in a policy, and then you should enforce those policies equitably, as we said. Efficiency is one that shouldn't be overlooked. If you are going to be having people come back to the office and maybe you don't have an office space for every single person anymore, maybe the office footprint has been reduced during the pandemic, you want to make sure there's as little as friction as possible for people to come back. So have a really easy to use system for booking an office space, making it really predictable so people don't come in and are faced with an issue of not having a desk to work at. Just a note on safety practices. So for decades now, there's been a requirement that all employers have an injury and illness prevention policy. So over the pandemic years, there have been additional requirements to that around COVID prevention. So hopefully everyone here has that nailed down. But last year, in 2024, there is now a requirement in California to also have a workplace violence prevention program. So it's a very detailed statute. You have to have a bunch of things ticked off in that policy around training, making sure that training is rolled out to the appropriate people. So anyway, just wanted to make a note of that, particularly for people for businesses that are maybe now occupying a bigger footprint and more people in the office. As far as COVID era guidelines, the emergency measures that were ordered a couple of years ago are actually expiring right as we speak. I think it's February of 2025 that those requirements to have COVID prevention procedures and that sort of thing, those are going to fall away, except around the record keeping requirements. So employers are still supposed to have to keep records of COVID cases in their workforce. That will continue for another year. And I think that is it in terms of our presentation. So happy to take any questions if we have any in the room or online.